Like most Americans, my response to the Supreme Court is typically a reaction to its most recent decision. Do I agree with it, or do I think the court had it wrong? But the broader question of how much power the Supreme Court should have is also worthy of our attention. Let me share with you the thinking on this question of some legal theorists. One school of thought, that of judicial restraint, holds that judicial review should be exercised sparingly. It argues that because the Supreme Court is an unelected body operating in a system based on majority rule, it should, when there's any doubt whether Congress or the President has acted constitutionally, defer to them, in that they were elected by the people to govern. An opposing school of thought is judicial activism. It holds that judges should actively interpret the Constitution in light of the fundamental principles it embodies. And though courts should not go out of their way to overturn the decisions of elected officials, they also should not hesitate to act when elected officials fail to uphold those fundamental principles. Over its history, the Supreme Court has had strong proponents of each doctrine. John Marshall, who served in the early 1800s and is widely regarded as the court's greatest Chief Justice, was an activist. He used judicial review to expand the court's authority and to promote national development. On the other hand, Justice Oliver Wendell Holmes, Jr., one of the nation's most influential jurists and who served in the early 1900s, argued that the judiciary should defer to elected officials unless they blatantly overstep their power. In recent years, judicial activism has been associated with liberal justices who've been accused by Republicans of legislating from the bench. And it's true, many of the Democratic appointees to the court since the 1930s have been liberal activists. On the other hand, today's conservative-dominated Supreme Court is also activist. In the past 2 decades, it has struck down more acts of Congress than were overturned in the previous half-century. In other words, it substituted its judgment for the judgment of the people's elected representatives in Congress. A case in point is Citizens United. In that decision, the court struck down acts of Congress and even repudiated previous court rulings that gave Congress the power to regulate campaign finance. There is no conclusive way to resolve the question of whether judicial activism or judicial restraint is the proper approach. The Constitution is dead silent on the issue. It says nothing about how justices should carry out their role.